Hey there, Legal Tea listeners. This is your host, Jenny Roselle. We are back to estate planning of the rich and famous, where we chat about celebrities in their estate planning. Today's episode is on Tom Petty, such a well-known musician, right? Like I referenced at the end of my last episode, a lot of us Indiana people like Tom Petty because he had that reference to Indiana at the very beginning of his famous song, Mary Jane's Last Dance. In all seriousness, Tom has got to be one of the best musicians of all times. According to his Wikipedia page, he actually had 3 albums land on the Rolling Stones' 500 Greatest Albums of All Time list, and had 2 songs on Rolling Stones' 500 Greatest Songs of All Time. So it's really, really hard to find someone that does not know a Tom Petty song. As always, before we dive into what happened estate-wise, let's talk about Tom's personal life. According to Tom's Wikipedia page, Tom married a lady by the name of Jane Benyo in 1974. Tom and Jane had 2 daughters, Audria and Anna Kim, who Anna Kim informally goes by Kim. Many years later, Tom and Jane divorced in 1996. But then, in 2001, Tom married a lady by the name of Dana York, and Dana had a son from a prior relationship, and his name was Dylan. As we know, Tom brought us many great hits over the years. So many songs, albums. I think I saw he had like 16 albums and tours, including worldwide tours. In 2008, Tom Petty and the Heartbreakers played the halftime show at the Super Bowl. They played a few of their greatest hits, such as American Girl, I Won't Back Down, Free Fallin', and Runnin' Down a Dream. After a wildly successful career, Tom was unfortunately found unconscious on October 2nd, 2017 at his home. A few months later, the Los Angeles County Medical Examiner shared that Tom passed away and did so accidentally due to a drug overdose, according to CNN, which the drugs were a combination of things that I probably can't even appropriately pronounce, but most were opioids, sedatives, and antidepressants. Following his passing, his wife Dana and his girls shared in a statement that Tom was dealing with a handful of medical issues, including emphysema, difficulties and pain in his knees, and even a fractured hip. Crazy enough, according to their statement, on the day of his death, Tom was informed that his hip injury had worsened. A portion of their statement said, quote, "It is our feeling that the pain was simply unbearable and was the cause for his overuse of medication. We feel confident that this was, as the coroner found, an unfortunate accident," end quote. A few months later, in September 2018, Dana, his widow, did an interview with Billboard, and she said that Tom had intentionally delayed his hip surgery, because, quote, he had it in his mind it was his last tour, and he owed it to his longtime crew from decades, some of them, and his fans. Man, that's so sad. So now shifting to his estate and estate planning, Tom had created a trust as part of his estate plan. So that means, yay, he did an estate plan. At least he did one, right? Which many celebrities who have passed away cannot say. Anyway, Tom's trust had his widow, Dana, appointed as the sole trustee following Tom's passing. And just keep in mind, reminder, that Dana was not the mother of Tom's 2 children. Dana is their stepmother. So Tom's trust stated that Dana was the sole trustee, but it also said that Audria and Kim were to be entitled to participate equally in the trust management. You know, as an estate planning attorney, I'm thinking, what? Like, what does that even mean? If they are entitled to participate in management, that is the role of a trustee, but yet he had only listed Dana as the trustee. Of course, this setup was a disaster. And fairly soon after the estate got rolling, Dana and Tom's daughters began disagreeing and their relationship deteriorated. According to a blog post by Holstrom, Block & Park, a law firm in California, quote, "The language in Petty's estate plan is clear about who should be involved in managing the estate, but it does not provide instructions about how the three parties should make decisions. That is troublesome," end quote. You are right, Holstrom, Block & Park. It sure is troublesome. So troublesome that Dana ended up petitioning the local probate court to ask the court to clarify how Tom's estate should be managed. Interestingly, well, it's interesting but not surprising, each side is interpreting the trust in their own benefit and favor. According to the Karp law firm, an estate and elder law firm in Florida, Audria and Kim argued that if they get equal participation in the management, they can sort of gang up on Dana and outvote her on things. So, for example, there's an LLC as part of his estate plan, and because they get 2 out of the 3 management votes, they outvote Dana so long as the 2 of them agree. Conversely, Dana thinks that the trust suggests that the 3 of them have to work, manage, and make decisions unanimously, not that majority wins. In the lawsuit, Dana claims that Audria and Kim, especially Kim, have, quote, demonstrated their resentment over their father's love of petitioner, meaning Dana, and her role in his life. She further argues that a manager should be appointed to assist in making significant decisions regarding Tom's estate, and specifically references Audria's, quote, erratic behavior, which has included sending threatening emails to the members of the band and blocking the release of recordings, which has jeopardized business dealings, end quote. After quite a bit of fighting and slinging not very nice things about each other, something happened, because really the next big update came sometime later in 2019 when it was released that Dana, Audria, and Kim actually reached a settlement and agreed to serve as equal participants. In a joint statement, hey, good for them, joint statement, they said, quote, "We are pleased to announce the formation of Tom Petty Legacy LLC to manage all aspects of Tom's legacy. We are committed to honoring Tom's voice, music, integrity, and his charitable spirit," end quote. The statement further shared that they have, quote, "resolved their differences and dismissed all litigation matters that had been filed related to Tom's estate. And each of them sincerely regrets that in their intense grief over Tom's tragic death, actions were taken that were hurtful to one another," end quote. And you know what? I love that. All too often do I see and hear estate litigation like this, that emotions completely take over and cause sometimes irrational decisions. Sadly, this estate world oftentimes ruins family relationships and relationships among the one in charge and beneficiaries, etc. Unfortunately, when emotions take over and rational decisions take the back seat, legal fees drastically increase. Here's a crazy story for you, actually. I was once involved in a case where the mother passed away, and the mother had 2 daughters who were inheriting. The 2 daughters started fighting, and we actually got to the point where we sat our client down and said, you know, if we don't settle or chill out, the only ones that are going to win in this case are us, the lawyers. Our client looked at us dead in the eye and said, "I'd rather you get my mother's money than my sister." I am being 100% serious in that story. And that is what I mean. Emotions over rationality. Yikes. And guess what? In that case, guess what? The legal fees completely consumed the estate. The only thing that our client got to say was that she won. Clearly, in that moment, that was more important to her than the money. And I often wonder if she looks back and regrets that decision. Heck, maybe not. That is how deep some emotions run. Sad, but true. So with Tom's estate, it actually makes me happy to see that Dana, Audria, and Kim settled, and actually did so pretty quickly. It didn't take years or decades like we've seen with other celebrity estates. I don't know enough about the case to know whether it was good lawyering, whether the lawyers successfully talked both sides to chill out and find a happy medium, or if it was the clients, realizing that no one wins if they keep on fighting. Regardless, I'm so happy it happened. So, beyond keeping emotions in check, what can we learn from Tom's estate? Well, a few things. Words are important. They're even more important in the law. I'm sure there was an idea, a reason Tom put Dana as the sole trustee, but added the provision of including Audria and Kim in management. I often tell clients, especially when they try to add or make up things beyond what the words in the document says, or maybe words in the document say, that I have to stick within the four corners of the document. Period. End of story. So it doesn't matter if someone claims, oh, Dad didn't really trust Dana. And I'm not saying, I'm just saying this merely as an example of things I hear from real clients. Or, Tom wanted to leave everything to the girls but didn't trust them to manage it. Neither of those statements are in these documents. So to be totally frank, I don't care. I just care about the words that are inside the document. Beyond that, it's such a frequently discussed topic on legalty, but here we are with yet another blended family. While this situation did not end up as World War III, it did still end up in court unnecessarily. Extra legal fees were spent because the court involvement, words were said and feelings were hurt, etc. I think if you are part of a blended family, you have to try your absolute hardest to extract emotions and truly and deeply look into your personal situation. Can your blended family honestly work well together after you pass? If you even have the slightest feeling that the answer may be no, then consider naming someone else as the person in charge. Name someone that is not related to any of the family and that has no stake. Sometimes people will end up picking a third party, like a corporate trustee, think a bank or a financial institution, or a professional like a CPA, a financial advisor or attorney, or even a company that specializes in serving in these roles. For example, here in Indiana, there's actually been a few attorneys that have come out and said, hey, I'll serve as executor, power of attorney, trustee, etc. Because so many clients of mine have asked for me to serve in this role, I actually have created and operate now from an LLC when I serve in that capacity. That's how often I'm asked. Yes, putting a third party as the one in charge comes with a cost, meaning they will charge the estate for their service. However, if things go awry and people start suing each other, I can almost guarantee that the cost of the third party will be significantly less than the legal fees from estate litigators in the lawsuit. Okay, let's wrap this episode up. Next week, we are back to a cautionary tale episode where we talk about real life clients of mine, real life cases, ones that I or my office have personally worked on, not celebrity level cases. And on next week's episode, we're going to be talking about estate planning with a farm. And you have to remember, I am in Indiana. And estate planning with the farm and the many, many excuses, yes, I'm calling them excuses, we hear when farmers choose to not do any type of succession planning for what the heck happens to the farm after they want to retire or after they pass away. So tune in for that next Tuesday, Legal Tea listeners. Until then, take care and be well.